Abusuya chairman Wontumi ne court cases no eno na yeguso drop ehon updated mama abusuya enye asem keto akra lawyer Andy appeal could be sisi and wa hand over to Atachia ono na yisi ano chairman Wontumi ne case no oba belidi na abusuya ene high court expose lawyer Andy appeal could be chairman Wontumi ne counselor or say or withdraw from the case abusuya sa case now or say or withdraw nyina no tactics plan bia omo ya mo pese omo de delay court na sa strategic plans ni nyina no high court ehun sa strategic plan no amagisi ano omo de expose chairman Wontumi ne lawyer eno kwa ka ho bi na echese omo accept the motion and as an application to withdraw from chairman Wontumi in the case no abusuya lawyer amaleba aba e de honsem bi aba betu ja momya ko na yenkonko tie ensema lawyer amaleba e de tuja e political highway so abusuya na answer na be kono Ghana ha open computer papa and a laptop papa na we use ya bora Peruzzi computers and accessories Peruzzi computers and accessories ho na obenya computer papa na chese we using the location enye your akwan owo Kumasi Buokrom estate phone number ya egu e screen ya 0247 030-108 and I say 0597-942-133. Peruzzi computers and accessories ho and a laptop ne computer papa fee. Say ukra low budget and as a high budget. Obema or high quality laptop na we use it. Lawyer Andy appeal could be in a strategic plan or person or debate court no exposing. Mommy and corner young concotti and honsem.
To start from this whole withdrawal of representation thing that Chairman Wontumi's lawyer is putting across has to deal with on Monday. The court after the trial, they fixed June 17 that if you are minded, you can file your address by June 17. Then the court says 3rd July is the day for judgment. Now, the lawyer, in fact, at the time at the court hearing, the lawyer had wanted more time. He had complained that it was too short because he has to go through the record of proceedings and everything. And he said that it was too short. The court said, okay, file it on. Then afterwards, he's now come up with this complaints about the timeline. He says disappointments. He's not in a mental frame that can give of the best representation. I mean, you have been a practitioner in the courts for many years. I mean, what's the thinking? What's your understanding of what could be happening?
My understanding is different from what the law says, so I'll come to my understanding. But the law is that Order 75 allows for this to happen. Order 75 of CI 47 allows for withdrawal of representation. And when you look at Order 75, the heading is what I have just said, withdrawal of representation. So it requires you to file a motion accompanied by an affidavit stating the reasons why you want to withdraw. I've actually done that in the Caught&Èxp0sè case. Now, if the application is heard and granted, then he ceases to be the lawyer for the accused person. But as we speak today, and on the day of moving the motion, he's still the lawyer for the accused person. Now, what would this do to the case? You just indicated that he's supposed to file written addresses or closing addresses. What it will mean is that, and that's on the 17th. 17th is when they file the case.
17th of June.
Then when is his application slated for?
Monday. Monday, coming Monday.
Not 7th, which is Monday is what?
Monday should be around 15th.
Okay.
Monday should be 15th.
Good. So what it means is that if the application is granted, he seems to be the lawyer, so he will not be the lawyer to file.
Within 2 days.
Yes. I'm saying, listen to me again. If the application is granted on the 15th,
okay, yes,
he ceases to be a lawyer, he has nothing to do with the case again. From that day, he's not the one to write the address. I'm telling you this.
So it will mean that Chairman Wontumi would have to get a lawyer.
So now, the court will now have to give Chairman Wontumi an opportunity to get a lawyer. They may say within 2 weeks or within 1 week. It is that lawyer who will now come to court for now a new date for him to also file. He will not be bound by the 17th. That's what I want to tell you. Everything will now shift.
And that new lawyer, I mean, if you are a new lawyer walking into it, you also have to study the material.
So that's where the bargaining will come.
The record of proceedings, everything.
That's where the bargaining will come. And that's where, and we're not talking about the bargaining, plea bargaining. No, forget, I want to say bargaining, these are my own words. That's where the new lawyer will go to court. And the judge will say, new counsel, file on the 20th. Oh, no, my lord, this is too early. And I have other cases. So, my lord, can we do it this way? That's where that one too will come. So, I'm just telling you practically what happened in court on that day. My only worry is the reasons he has given. The emotional imbalance and psychological trauma. I don't know, but whether that is a good enough reason for you to want to withdraw from a case. You are not alleging bias against the judge, like I did in the Caught&Èxp0sè case. You are not alleging that your fees have not been paid. You are not alleging that the client is misconducting himself, like, what is his name, Wontumi, is misconducting himself before you. But to say psychological trauma, you lost cases, they rule against you, you rule against you, you lost. Then if that were the case, to be honest with you, Chachi Chikata would have stopped practicing. Look at the Supreme Court. Every motion he brought, these are people he even taught. Oh. You remember that? People who taught on every motion he brought, they cut it to size. So I don't think that for me is a good enough reason for him to want to withdraw from the case. But let's see what the court says. And if it is granted, I have already told you what will happen. It will mean that the judgment cannot be given on the 3rd July.
I mean, you said your reason is not backed by the law. What was the other? You've not given me that reason yet.
Well, I see all these are delay tactics. That is what I wanted to tell you. It's all delay tactics on the side of Wontumi and his lawyers to slow down the process. And who knows whether they are back. I've heard people, I've heard somebody, one of the MPP guys said that their elders are going to see Mahama. I don't know whether you saw something like that.
Yeah, I saw it.
So me, I don't know. For me, I don't know. I don't know what matters. But me, I know it's a delay tactic. What happens after that, I am not in a position to talk about. But I know that it's a delay tactic.
I mean, it's not too late in the day if it's a delay tactic. Because at this stage, as far as the delay goes, it's in respect of the filing of the address, which logically you can't delay it for as long as you can.
In this country, don't forget that we have other non-legal factors. You see, there are non-legal factors. Who knows? If a Malam says that, oh, they delay kakrawa and nama will be who knows? There are also non-legal factors. So me, I don't know. I'm not in their camp. So this delay to them would inure to their benefit, and that's why they are persistent. To them, it will not to their benefit. But for you as a lawyer, strictly speaking, a slap that will come either way, it's better to take it now, isn't it? So the judgment will still come, even if it is 30 years. Is it not better to take it now? That is your argument. I see you thinking like a lawyer. But I'm saying that there are non-legal factors in these matters, and that is what you should factor in.
Finally, generally, how do the courts treat such requests? Have you seen any that the court has decided that no, continue representing the person?
First and foremost, all parties must be served. So if there were...
Including the clients as well, Chairman Wontumi himself?
Oh, no, he's filing the thing, so he has a copy. But all parties. So, for instance, in my case, it was the Electoral Commission, it was Attorney General, and it was a plaintiff because I was a defendant. So, if all are not served and you come to court, the judge will not deal with the matter. Have you served this person? Have you served? Is there proof of service? All those matters also go a long way to slow the process. Now, when you look at our legal professional, our etiquettes, the court and the judge can insist that you should continue with the case. But in practice, and because I have also
taken advantage of this rule before.
Yeah. It's difficult for a judge to insist. Because if the judge insists that you should be on the case, it is going to be at the detriment of the accused person. You can boggle up, you can what's the word? Is that boggle up? You can mess up with the client's case. You can literally mess up with the client's case. So 90% of those cases the court grants. And the court would normally want to do this expeditiously so you can get a client, you can get a new lawyer. Yes. So I foresee this dragging a bit because of the processes involved and also for the client, and that's the accused person, to get a replacement. All this will drag for some time.
I see. Mr. Dantua, I mean, I don't know where you stand on this leg. I mean, they are taking advantage of. I don't know what's playing on your mind at this point in time. Reading the affidavit and seeing some of the things he's saying in there.
You know, when the topics were sent to me, I mean, on the hindsight, I really didn't even know how to grab it because I felt it was quite a sensitive issue involving Chairman Wontumi, my fidelity to the law, and of course the new twist about how he, of course, together with his counsel, filed the plea bargain. I mean,
we'll come to that aspect.
We'll come there, yeah, but generally, it creates a certain presumptions and assumptions in the minds of people and puts a certain perception even in them, and that may have a persuasive effect even on the ongoing case that is pending the determination of the court. The court is here to give a judgment to it. So I mean, we are rational beings. If you are pursuing two matters and one of them you come and say, well, I'm guilty, so on that subject matter, ordinarily I want to enter a plea bargain rationally. And especially how Ghanaians are, our thinking has been programmed. Any rational person could read other meanings to anywhere. People could then say that, well, then it presupposes that.
How has that thinking been programmed? By who?
Oh, I mean, it's been programmed in a way that I'm not sure. I think it's the context is literal or figurative, not necessarily to suggest that people have been programmed in our mind, but the point I want to make is that we have a line of thinking. Let me put it that way. We have a line of thinking. Let me put it that way. But the point I'm making is that when I saw the plea bargain thing, it really got me a bit concerned.
No, but we're not discussing.
No, we'll come there. I don't know whether you get the point that I'm making, if I'm allowed to flow. The point I'm making is that because the plea bargain thing came subsequent, that was yesterday, any other person could speculate even to his other ongoing cases, and for me, that I felt it was something that maybe probably the lawyers could have also, but of course they have the full facts. But now coming to the substantive issue, you see, in all the discussions that we are doing, I mean, my fidelity is to the law first, and there is this thing that we all know as lawyers, and of course, even as ordinary Ghanaians and everybody, the presumption of innocence. And I'm minded and guided on that accord, because as of now, with respect to the subject matter and the case that we are talking about, there has not been any judgment on it. I think all of us are just thinking outside the box, looking at maybe what his lawyers have said, based on by his conduct and inference. One can say that probably he's saying that the court is being biased to him, and then people may speculate to say that, well, is he afraid of losing the case or what? But that's that. I think it is important for all of us to remind ourselves that Article 19 places a hallowed injunction on every accused person. So the discussion should be situated in that context. But I also want to quickly add that, you see, this discussion, there is the political
What does
conversation.
Article 19 say? Because the people won't understand what you mean by
No, I
Article
spoke
19.
about Article 19 on that it places a hallowed injunction on accused person when it comes to presumption of innocence. So this discussion should be discussed in that context. But I'm saying that even moving
Innocent
beyond that,
until proven guilty.
there is, yes, innocent until proven guilty.
Yes.
Even going
Say
beyond
so that they understand.
No, you are affecting my flow. What's that? Even
And people
beyond
need to
that.
understand these terms
Very well,
so that they can follow
very
us.
well, very
Uh-huh.
well, very well, very well. Even beyond that, there is, you see, this conversation, for me, if you ask me, they are in two folds: the political conversation and also the legal conversation. Wontumi is a politically exposed person, and so you cannot have this conversation without bringing the political context. Of course, I'm a lawyer; I'm also going to address the legal context. But he's been being prosecuted on the reasons of Galamsey. I mean, I commend the government for that, because at the end of the day, we want our water bodies, everything to be clean. But except that, you also cannot run away from that issue of the political bit. That yes, I mean, he may, for lack of better words, also be a victim of somebody who is just being scapegoated to make a case, especially when it comes to the fight against Galamsey.
Someone who has 3 cases filed against him.
Yeah, I'm saying that's what I'm saying, that there is a political bit.
That would be a massive scapegoating agenda.
Yes, but because the point is that, would you honestly tell yourself, or can we all of us honestly agree that so far as Galamsey is concerned, when it comes to the big waste controlling Galamsey, it is only Wontumi that probably does Galamsey or engage in illegal mining? Clearly, no. They may be.
Produce the names of the other ones, so we'll see.
Yeah. Oh, I have
Produce
been.
their names,
It
so
looks
we'll
like
see whether they will go for them or
it
not.
looks like I've been interdicted from all angles.
No. Just produce their names. Say that
let's-
that's so and so.
let's do this
Abraham,
way.
I'm not
Let's
in
allow him
government.
to.
I'm not in government. I'm not the one responsible for
So you
producing
can't
the
just
product.
make a statement
No, I am
without,
saying that you cannot also rule
without
that fact.
evidence.
No, I'm saying that no, but you can make reasonable inferences. You can make reasonable inferences. That is how the human mind is. We are made to make reasonable inferences, so that you cannot say that in the case of Wontumi, if you look at how the matter has been handled. I mean, Andy complained about the rush and what have been. I mean, those ones are matters of the court. But I'm saying that it will not be far-fetched for anybody to say that, well, assuming even without he committed offense or he did not commit the offense, he can as best also be described as being scapegoated to make a case, of course, for the government, which I understand. I mean, it's a responsibility for the government to do that. But I'm sitting here as a secret. If I've not gone to mine before, would anybody scapegoat me? Clearly, no. But I'm saying that you cannot take away that bit. Then it comes to the legal aspect. Andy has raised a lot of issues. Yesterday, I listened to him on Asempa, and he raised all those concerns. Yesterday, I contacted him on this same subject matter when I had the topics. I think he shared some few notes with me to read on it, but also shared some of the interviews he did, at least to make a reference. I think, like Amalaba said, I'm sure it's a matter of strategy. Maybe some way, somehow, to buy some grace period or time. Because obviously, as soon as a lawyer withdraws, there will be a new lawyer that will come into the matter. And the judge will have to give that lawyer some reasonable period of time in the spirit of natural justice to also study the file or the docket and also come back with the final written address or the written submission that the judge has ordered them to do. But looking at the frequency and the flow of the case, I do not even think any lawyer who comes in may have that liberty in terms of more time to file the address, especially when the judge has already given an indication of when she is going to rule. And it's also important to also add that even though Mr. Piakubi had made an application to the court that he wants to withdraw his services, if you read the LI 2423, the section 85 to, I think 85 to 88, it addresses those concerns, that those ones may be within the prerogative of the judge, because at a time like this, and of course, looking at the duration of the trial and where the trial has got into, you cannot just withdraw. You will need leave from the court, and the judge may decide that I'm not going to grant you the leave in abandoning the matter. And so, for that matter, you probably have to be ordered to continue the case. But like Senior said, in matters like this, it mostly does not happen. But bottom line is that for me, yes, I believe in accountability. I believe that people should be held responsible for their actions and inactions. At the same time, we must also be mindful that it is the law that should guide all of us. I have seen laws being abused on so many times. I think it was Montesquieu who put it very succinctly, that the highest form of injustice is the one perpetuated under the umbrella of the law and in the name of justice. If you recall, there have been bad laws, there have been laws that has been abused. I, for instance, have always cited the example of the Chief Justice house he was removed. If you compare to the normal practices and how other Chief Justices and how other justices of our courts have conducted themselves, and how her individual case was treated, it was a clear case of how the law can be tilted to achieve a certain purpose.
Okay, abusuya we ne ensema ekoso our political highway to chairman Wontumi ne counsel lawyer Andy Apiakubi na HSL lawyer Amaleba ebaya obeliki info bi e de kire bedamase somo je pene kokoti sa ensemo e de mai aha e gossip politics TV so bedamase.